Hey there, welcome to Help Solve the Case. I'm Christine Burke, retired police detective and sergeant, current law enforcement expert, and forensic genetic genealogist. And we are here today because, oh my goodness, this explanation will say it all. Let me read it to you. New trial pending. Prosecutors will not seek death penalty. The U.S. Supreme Court found Oklahoma prosecutors suppressed and failed to correct false testimony. Why it matters. This prosecutorial misconduct is the highest profile scale. SCOTUS found it, not just an advocacy group. Okay. So it's talking about witnesses lying and prosecutors overlooking it. And oh my goodness, sounds like a scandal, doesn't it? This is the Richard Glossip case out of Oklahoma. I wanted to go through the Supreme Court opinion because my news brief, my assistant says the Supreme Court found it and they apparently found it egregious. So we're going to get into it because you know I like everything criminal justice and we like to see all sides of a case, all right? So thank you for being here. I would love it if you would like, subscribe, and share. Everything that you do here is so important to me because it helps me help so many more people identifying unknown human remains, working on innocence projects, helping solve cold cases, you name it, I'm down for a good investigation. But we've got to fund it and we've got to have resources. So you are a huge part of it. And I just love having you here. So let's get into it. Let's see exactly what the Supreme Court uncovered. Isn't that kind of cool that the Supreme Court was doing our investigation for us? The Supreme Court was doing the job that they were supposed to do, or should we say, the lower court and the prosecutors should have done. Scandalous, isn't it? All right, stay tuned. Okay, hopefully you can see it here. I tried to blow it up a little bit so we can see it. And this is the Supreme Court of the U.S. Like that is the, all the way up. Actually, I'm going to mention this now because I was talking to somebody in one of my local groups, and I think they didn't realize that when a court case gets retried or whatever, it goes up to the next level. Okay, so it would go up to, if it was in the county court, it might go to the circuit court. If it was in the circuit court, the highest court in the state, then it goes to the state Supreme Court. And then from there, it goes up. Okay, it might go up to the district court and then it's going to go to the Supreme Court, depending on how it is. So when it is up here at the U.S. Supreme Court, like that's it. That's the final stop. Okay, so here's some of the facts of the case. So they got this. This was argued in October of 2024. It looks to be that was about what, 4 months? October, November, December, January, February, 5 months. It looks like they're getting about 6 months. One of the last cases, I forget, was that the Murdaugh case. They're coming back about 6 months. So in 1997, this is an old case, right? Justin Sneed beat, and I'm going to do my best. Everybody, this is a conviction case. This is overturned. So now the defendant is presumed, depending on how the decision came down, I'm not exactly certain, presumed innocent. This is alleged, This is, I'm reading and talking about what the U.S. Supreme Court says. So I don't want to have to interfere and, interject every time we're talking about something. So I want to be very clear that we are reading the decision of the court, a fact put down by the court. Okay. And if you have a problem with that, go back and read the document. Okay. Because I want to be able to narrate the case and talk about the case just like that. And again, we're not on one side or the other side. We're talking about the criminal justice system, how we can make it better, what happened, what went wrong, what do we need to pay attention to, right? And they're saying, the Supreme Court, it sounds like they're saying that prosecutors did a big boo-boo here, which is not good, okay? Everybody needs to do their job properly so we have justice, okay? So in 1997, Justin Sneed beat Barry Van Treese to death with a baseball bat at an Oklahoma hotel owned by Van Treese and managed by petitioner Richard Glossip. Okay, so we want to set the set the scene. So our person that we're focused on, Mr. Glossip, he's a defendant. He's still a defendant. He's going to be retried. Defendant Glossip, allegedly, right, innocent until proven guilty, managed a hotel. And Justin Sneed beat Barry Van Treese to death at an Oklahoma hotel. Okay, so Barry Van Treese was the owner. Glossip was, and Justin Sneed beat Mr. Van Treese. Glossip, our defendant, initially made inconsistent statements to police about Sneed's role in the murder, but he ultimately told police that Sneed admitted to killing Van Treese. So somehow Glossip saw something or heard something, okay? Sneed later claimed Glossip had asked him, this is a little convoluted, so we need to get this straight. Sneed later claimed Glossip had asked him to murder Van Treese because, among other things, Glossip had wanted to steal Van Treese's money. So we got Van Treese is the hotel owner, probably has money or is managing the receivables for the hotel. We've got Glossip, who's the manager, and then this guy, Justin Sneed. So we don't know. Is this a murder for hire? Is Justin Sneed a patron that something happened? We don't know. We're going to continue reading. Glossip maintained his innocence and refused a plea deal that would have had him avoid the death penalty in return for testifying against Sneed. Okay? So let's think about this situation. Again, it is a little convoluted. I'm trying to get all my players straight because we want to talk about motive. Not only motive for the crime, but motive for how the defense is going down and how the prosecution is going down. And when I say going down, I mean how they're going to construct their case. So Glossip knew something about what happened, we can imagine. And Sneed said that Glossip asked him to murder Van Treese. So kind of like I talk about kids in the cookie jar, right? When they say it was him, it was him, it was him. Some, what they call the sod defense, some other dude did it. It could have been easy, depending on Justin Sneed's role, to point the finger at Glossip, okay? Because there's a motive there. Now, what's interesting to me is Glossip maintained his innocence and he refused a plea deal that would have had him avoid the death penalty in return for him testifying against Sneed. So where else recently have we seen a plea to remove the death penalty? Koberger, right? And we don't understand that. Like, that's confusing. We've gone through that case when we've seen the evidence and different statements from different people, okay? So typically, when people are maintaining their innocence and they are steadfast in their innocence, even to avoid the death penalty, I think you have to go, okay, right? Because I've had clients, and when clients are innocent, you're innocent. Like, you're not going to agree to something you didn't do, right? Okay. So we have to think about all these moving parts. Sneed then testified against Glossip at trial in exchange for avoiding the death penalty, and Sneed's testimony was the only direct evidence connecting Glossip to the murder. Like, this is a huge paragraph here because it outlines the whole thing. Now, let me tell you, in a case like this, now it says that Sneed is the only thing that tied only direct evidence connecting Glossip to the murder. When you have multiple people involved, Okay, and we've been talking about the Brady case too. And Henry Tenen was offered a plea deal to testify. That makes the prosecution's case stronger, right? And he reneged. He's like, I'm not doing that anymore. Okay, what's the reason for that? Typically, and I know as a cop, before we even get to prosecution, you want somebody to dime out, or whatever you want to call it. You want somebody to confess and to implicate the other people. Okay, as a cop, you pretty much have the read of the room, as they can say, and you know what's going on, and you want someone to spill the beans. All right, makes it easier. So in this case, prosecutors apparently, and I don't know what order this was in, that it's called Let's Make a Deal. If they feel that their case, and I'm not saying, I'll say sometimes, if they feel that their case is not good enough on its own, they will offer, let's make a deal. Okay, let's make a deal. And when Glossip, I'm assuming they offered it to Glossip first, and Glossip said no, they gave it to Sneed. And so when you're a defendant, and if there could be guilt involved, you might want to be the first one to raise your hand to be a participant in Let's Make a Deal. Just throwing that out there, okay? Because they like to leverage that, okay? All right. So that's interesting. So then Sneed testified against Glossip. The jury convicted Glossip and sentenced him to death. Now that's interesting because we have up here that Justin beat Barry Van Treese to death, not Glossip. Now, we also have felony murder sometimes comes into play, where you're at the crime, you buy the time, okay? You're there, you take the ride. So, because it was a death penalty case, apparently, again, I'm only in this only in the first paragraph, I don't know. Because Glossip was there, according to Sneed, he takes the same ride. But Sneed didn't get the death penalty because he copped a plea. Okay, he testified. Okay. The Oklahoma, okay, so the jury, this is like a convoluted case. The jury convicted Glossip and sentenced him to death. The Oklahoma Court of Criminal Appeals, okay, that's before the Supreme Court, overturned the conviction because the defense had been ineffective in challenging Sneed's testimony. That's important. And the remainder of the evidence only weakly corroborated Sneed's account. So they went with ineffectiveness of counsel for a retry at the lower court level, is what it sounds like. At the retrial, Sneed provided inconsistent testimony. This is the Supreme Court saying this, it ain't me saying this. Provided inconsistent testimony on potential motives for Glossip's murder. For Glossip murdering Van Treese, I'm assuming. Sneed also denied that he had been prescribed lithium or seen a psychiatrist. After the defense established through the state's medical examiner that Van Treese had been attacked with a knife as well as a bat, do we have two offenders? Why do we have two methodologies? Sneed testified that he had repeatedly tried to stab Van Treese in the chest with a pocket knife. Okay, that could be a problem. Like, I'm thinking about, like, I mean, that's not funny in any sense of the word, but I just pictured this little pocket knife that I had as a kid. It had, like, the fingernail cleaner. Like, it was really tiny. like this big. Sorry, guys, that's not funny in any sense of the word, but depending on the pocket knife, I could see how that could present a functional problem. Okay. But Sneed had previously denied stabbing Van Treese when both were questioned by the police as well as at Glossip's first trial. So this is important too, because either on the prosecution side or on the defense side, one of the goals is to do what's called impeach the witness, which means ruin the credibility of the witness by bringing in these prior statements and saying, well, I have here where you testified in the first trial that you said this, and I have here where you told the police this, and I have here in the phone call where you said this. You've seen them. Can you read this here, line 14 for me, and tell me what does that say? Okay? So then the jury's like, can't trust what they say. Okay? So impeachment is something that we try to do. And we try to do that on the street too. All right? During interviews and interrogation. You compare, contrast. We'll leave that there. Okay. So Glossip moved for a mistrial based on the prosecution's failure to notify the defense about Sneed's change in testimony, which the trial court denied after the prosecution disclaimed any knowledge about the change. Okay, that is a loaded statement. Glossip moved for a mistrial. So this is the second trial, based on the prosecution's failure to notify the defense about Sneed's change in testimony. So if it was some kind of a proffer or some kind of a whatever, especially if it's exculpatory, and I'm not an attorney, there has to be disclosures throughout this process. So they moved for a mistrial. It sounds like during this second trial, during the retrial, they moved for a mistrial. That was denied. And Glossip was again convicted and sentenced to death. And a closely divided OCCA affirmed, okay, holding that circumstantial evidence suggesting Glossip had mismanaged the hotel, combined with Glossip's concession that he had been dishonest in his initial statements after the murder, sufficiently corroborated Sneed's testimony that he killed Van Treese at Glossip's direction. Wow. You guys, this is loaded with criminal justice intrigue. So they're saying because of the appeals court on the second retrial appealed that, affirmed, that means they agreed that because Glossip had mismanaged the hotel and the fact that he said he was dishonest in initial statements after the murder corroborated Sneed's testimony that he killed Van Treese at Glossip's direction. I'm like, okay, let me tell you, can I tell you how many times defendants lie to the police? Really? Really? Okay. I'm shocked. Okay. And that he mismanaged the hotel was a reason, not that it indicated motive. They're just saying here in this statement, this is what the Supreme Court is saying, that those two things, didn't tell the police the whole thing the first time, happens every day, all day, every day, and that he mismanaged the hotel, corroborated Sneed's testimony, made Sneed's testimony true. That, wow. Think about that. Like, so, so you lie to the police about speeding and your car is dirty. Your car is disorganized and you're going to go to jail for something someone else said. It's okay. Okay. We'll keep going. Glossip subsequently filed. See, this is where the truth and the procedure, this procedural stuff is. I tell people it is to us about guilt or innocence, morally and ethically. But in the criminal justice system, it is about this procedural thing, okay, that gets all out of whack. All right. Glossip subsequently filed several unsuccessful habeas petitions. Concerns over the integrity of his conviction led a bipartisan group of Oklahoma legislators to commission an independent investigation by a law firm, Reed Smith. In June 2022, Reed Smith reported, quote, grave doubt, end quote, about Glossip's conviction, citing factors such as the prosecution's, bad words, deliberate destruction of key evidence. Stresses me out. As a cop, stresses me out. And the false portrayal of Justin Sneed as a nonviolent, quote, puppet, end quote. The state then disclosed, oh my God, I'm sorry guys, like this is so bad. You hear about this stuff, like this turns my stomach. The state then disclosed 7 boxes. I can't even breathe. I need to take a breath. Don't get into a job if you cannot uphold the standards for the job. When somebody's life is on the line, please. Okay, let me try to do this again. Let me try to read the sentence. Sorry. The state then disclosed 7 boxes of previously withheld documents, including letters suggesting Sneed had considered recanting, eyebrows, and a note from prosecutor Connie Smotherman to Sneed's lawyer noting they should, quote, get to, end quote, Sneed to discuss his problematic testimony about a knife found in Van Treese's room. Okay. I could be wrong, but I believe there is an ethical canon in the bar that a lawyer cannot suborn, however it goes, perjury. Okay? I'm pretty sure. I'm not a lawyer. But my lawyers can chime in there. Deep breath. Okay. Glossip filed for post-conviction relief based on this evidence and evidence revealed by Reed Smith because he had failed his habeas before. Glossip also argued that during his second trial, Smotherman had interfered with Sneed's testimony about the knife in violation of the rule of sequestration, which prohibits witnesses from hearing each other's testimony. So let me explain that. They call that invoking the rule. And what that means is when the trial is going on, or a hearing or some sort of testimony, so that witnesses don't not only get confused, get biased or whatever, or know the angle of the testimony, they get separated. You have to stay outside. So what they're saying here is somehow somebody heard about the knife or somebody heard about somebody else's testimony. They say here that Oklahoma waived any procedural defenses to Glossip's claims and asked the OCCA, that's the upper level, to deny the claims on their merits. So it sounds like that the Oklahoma said, look, we're not going to look at any of the procedure here. We're just going to say that these don't have any merit, just, any merit. So the case was denied the appeal, and it says procedurally barred and meritless. Oh my gosh, it gets worse. The state then discovered additional documents revealing that Sneed had been diagnosed with bipolar disorder and prescribed lithium, contradicting his trial testimony. So now he's committed perjury. And who had these additional documents? Did the state have these documents and know? I think we got it in the next sentence here. Did the state know that they were suborning, however that goes, perjury? The attorney general determined that Smotherman, that's the prosecutor, had knowingly elicited false testimony, bothers me, from Sneed and failed to correct it, violating Napui versus Illinois. We've heard that one before. Okay, that's a precedent, U.S. precedent, which held that prosecutors have a constitutional obligation to correct false testimony. Okay, so it's not only a bar thing, an ethical thing, a constitutional obligation to correct false testimony. Glossip filed a successive petition for post-conviction relief, which the Attorney General supported, conceding multiple errors that warranted a new trial. The OCC denied the unopposed petition without a hearing, holding that Glossip's claims were procedurally barred under Oklahoma's PCA, post-conviction, and further stated that the state's concession was not, quote, based in law or fact, end quote, because it did not create a Napui, or however you say that, error. The court stayed Glossip's execution and granted certiorari, means they certified the verdict as the sentence and everything. So, holy moly, held. This court has jurisdiction, that's the Supreme Court, to review the OCCA's judgment. The independent and adequate state ground doctrine precludes the court from considering a federal question if the state court's decision rests on an independent and adequate state law ground. Okay, so this part right here is the Supreme Court telling us whether they have a right to review this or not, okay? So they're saying yes, they do, because the independent and adequate state ground, remember this nationwide Supreme Court, precludes the court from considering if the state court's decision rests on independent and adequate state law ground. But they're saying, the Supreme Court says, OCCA's application of the Post-Conviction Procedures Act is not a ground. It doesn't meet that standard, because their decision to apply the Post-Conviction, whatever it is, Procedures Act, depended on its antecedent rejection of the Attorney General's confession, that's a strong word, of a Napui error, which was based solely on federal law. The OCCA held that the confession could not overcome the PCPA's limitations because it lacked a basis in law or fact, specifically finding no Napui error. Okay, and they're going to go into some here, blah, 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 blah. But they're saying, no, we have a right to look at this, okay? Then, let me just see how far this is going to go. Yeah, okay. So then, the prosecution violated its constitutional obligation to correct false testimony. So they're saying, yes, they did. Under Napui, they're talking about it violating the defendant's 14th Amendment to due process. Yes. They talk about how they establish it, that it would have affected the jury's judgment, and the Oklahoma AG, like, that's pretty strong, coming in here saying, hey, bad stuff happened here, okay? And Smotherman's notes, that's a prosecutor, she had a pretrial conversation with Sneed, at which he mentioned this lithium and a doctor, okay? So, they said that Sneed's testimony was the only direct evidence of because Sneed's testimony was the only direct evidence of Glossip's guilt, the jury's assessment of Sneed's credibility was material and necessarily determinative. So it did affect the jury's outcome. Okay. So, do we want to go through this? It is 82 pages. I know some of you have talked about not going through older stuff, but this is going to be background for this new trial. We potentially have an innocent man here. I don't know if this would be something the Innocence Project or whatever would take up, but we have the Supreme Court here, if we think about this, saying that pretty much the only thing that convicted Glossip was Sneed's testimony, and it was false. Like, so how is the prosecution going to put their case back together? Do they have to go back to the drawing board and reinvestigate the case? I think that's very interesting. So I'm going to stop here, and you guys tell me in the comments below if you want to dive further into this, or if you want to follow this case, because this is a bad boo-boo. This is a bad boo-boo on the prosecution side. No bueno. We don't like this whatsoever. Okay? So let me know. Thanks for being here. I really would appreciate it if you would like, subscribe, and share. And let me know here below the video or in the community what other cases you would like to see. Feel free to drop a link. I can't talk this morning. Drop a link to a document if that's something you'd like me to review, or maybe put it in the community. If there's a document, not just this case, but another case, put it in the community, and then we can all vote on it or whatever. See if you want me to go over that. All right. Thank you. And I will see you on the next one.